My name is Charles Suter. In the next few minutes I'll be presenting information on civil harassment mediation. I'm a volunteer mediator for the municipal courts in Orange County, California. This presentation is intended as guidance for people involved in an interpersonal conflictual situation with another party who are contemplating or have taken legal action to gain protection via a restraining order. My main message here is that mediation seeks a peaceful and respectful resolution to conflict. Mediation is another alternative for settling disputes besides legal recourse. Mediation is an informal dialogue process for resolving disputes and conflicts between people, as opposed to a formal trial with a presiding judge in a courthouse. A civil harassment dispute is focused on socially inappropriate behaviors, whether it be physical or non-physical, between multiple parties. A civil harassment court case is a serious matter because the normal remedy is a court-ordered permanent, that's up to 5-year restraining order against the defendant. However, the standards for awarding a permanent restraining order is high and difficult to obtain for just the typical violation of social norms. Thus, it is in the best interest of all parties to make every effort to resolve any dispute by themselves without further legal action. In mediation, the goal is not to fix the blame, but instead to fix the problem by separating and or limiting future provocative interactions between the parties and or simply introducing civility guidelines for future interactions for all parties to follow. If mediation is conducted under the guidance of the courts, and if the parties come to a settlement mediation, their agreement will be accepted by the judge as the resolution for their court case. If not, if they don't come to an agreement, a judge will hold a trial and render a decision regarding a permanent restraining order. Proposition 1. If the civil harassment case goes to trial, there will be some serious consequences. The defendant will lose some civil liberties and privileges if a restraining order is granted. However, the plaintiff may not be granted a permanent restraining order, and if that is the case, without a restraining order, the conflict could very well continue. Once a plaintiff has been granted a temporary restraining order by the court, the parties have a choice of settling their conflict either with trial before a judge or beforehand with mediation to work out their own settlement. If a case goes to mediation and the parties do not come to a settlement on their own, then the case will be heard by a judge as to whether there are sufficient grounds for ordering a permanent restraining order against the defendant. The plaintiff has the burden of proof and must present evidence that the defendant has committed any of the following. A physical assault, battery, or stalking. B, made a credible threat of violence which a reasonable person would be placed in fear for their safety, and or conducted a course of conduct which is designed to vex, harass, annoy, which serves no legitimate purpose. If the nature of the harassment by the defendant against the plaintiff meets the standard of the law, a permanent restraining order will likely be granted, again up to 5 years. The defendant will lose some civil liberties as a result of having a permanent restraining order placed against them, including the possibility of arrest if the restraining order is violated, and they must surrender any firearms. If the nature of the alleged harassment does not meet the standards of the law, the case will likely be dismissed and the conflict in effect may not be resolved, even though the judge on the bench may admonish both parties. There is a real possibility that the conflict may continue as well as future legal actions, so both parties should be motivated to work diligently towards a settlement. Proposition 2. In mediation, the goal is to find a way to avoid end the conflict. That is the focus. No attempt will be made to determine who is right or wrong. There will be no review of how the conflict started. There will be no review of the history of the conflict. In mediation, the goal is simply to stop the continuation of the conflict by disengaging and separating the parties directly involved in the conflict, and or disengage any third parties that might want to continue the conflict. No attempt will be made to determine fault, liability, or blame against either or both parties. The mediation is focused on future behaviors and not on past incidents, except perhaps as examples to be avoided. The end product of mediation is a written agreement regarding the mutual interactions of both parties to stand down from future offensive behaviors. Mutual apologies, forgiveness, and relationship mending, while although desirable, are not the focus of mediation and thus not mandatory for a settlement. Proposition 3. In mediation, ways are sought to remove the sources that spur conflict. This includes the avoidance of future offensive behaviors and the setting of appropriate separation distances. We'll also determine how best to handle future unintended contact, especially if the parties live in proximity, live in the same neighborhood, shop at the same stores, work in the same office building, and also how to disengage any possible third parties. Most often, the parties will work collaboratively to determine how to avoid future hostile incidences that might lead to future conflict. No terms of settlement will be suggested or imposed by the mediators. All aspects of a settlement will be determined by and agreed to by the parties themselves. My final message: if you make a sincere effort, interpersonal conflict can be resolved. It has been my experience that if both parties make a good faith effort to resolve their conflict in mediation, they nearly always find a way to end it, avoiding a trial and a potential permanent restraining order against the defendant. So I hereby encourage both parties to make a good faith effort to come to a resolution to their particular conflict.